We do not take people's constitutional rights away from them in this country based on mere allegation. Our standards are higher than that. We are the armed attorneys. Today we're talking about one more gun law that has been held unconstitutional thanks to New York State Pistol and Rifle Association versus Bruen, and it's a biggie. So stick around. We're going to talk about what's happened, what comes next, and how it might affect you. But before we get started, show your support for the Second Amendment by hitting the like button.
And today we're talking about, I'm going to apologize in advance, Zaki Rahimi. Yeah, sorry, Mr. Rahimi, if we're mispronouncing your name. Out of the Northern District of Texas, he was convicted under 18 U.S.C. 922 G8. That's our prohibition for possessing firearms and ammunition for certain protective orders. After his conviction, he had an appeal denied. New York State Rifle and Pistol Association v. Bruen landed. The panel reopened up, and now they are deciding and have decided whether they think that conviction should stand. Now, we got three judges, Judge Jones, Ho, and Wilson, and the case itself, and typically this is just general law. I say this about all cases, when usually you have bad facts makes bad law. We have kind of bad, rough facts here, but I think we get an outcome that I think we all can enjoy. But what we're talking about here is Mr. Rahimi, between December 2020 and 2021, he was alleged to be involved in 5 shootings across Texas. They identified him, got a search warrant, knocked over his house, found a rifle and pistol. He admitted to possessing the firearms. He also admitted being subject to one of these protective orders that would have restrained him from harassing, stalking, or threatening his ex-girlfriend and his child. So by all accounts, prohibited under federal law, saying can't possess firearms and ammunition. He was indicted for breaking that law, convicted. We get to this appeal, and what do we see happening now?
Well, so first let's say what law he broke, which is 18 U.S.C. 922 G8. And what that does is say that people who are subject to certain protective orders do not have their Second Amendment rights while they're subject to such orders. Those orders have to be ones in which you knew that the order was, that the hearing was occurring and you had an opportunity to participate. So it can't be an ex parte order, but virtually anything else. And then that order has to restrain you from harassing, stalking, threatening an intimate partner, spouse, child, putting that person in fear that you're going to do bodily injury to them. And here's the and, in addition to those things, it has to either find that you are in fact a credible danger to this person's safety, which is a pretty high standard.
Sounds reasonable.
Or just simply prohibit you in explicit terms on its face from harming that person, which virtually all of these orders do.
Yeah, I would say to that first part, on its face, of all the things in the world, does an average person is going to say that doesn't sound too bad, but 95+% of these orders fall into that second category, which is a lot.
Correct. And bear in mind that it is very, very easy to get one of these orders granted. In fact, it is just par for the course when you've been charged with a domestic violence offense. So essentially what we have here is a law that is going to stop you from possessing firearms and ammunition based on nothing more than pure allegation, not conviction, right? Not
beyond a reasonable doubt.
Not beyond a reasonable doubt. Simply, it is alleged you have committed a family violence offense. This order will be entered against you. Your gun rights are gone for the pendency of the order. And these orders can actually be lifetime orders.
No, we have a client in Harris County who has one of these lifetime protective orders, never convicted of a crime, and maybe gets his gun rights back. We'll look at this case, but the court correctly applied the New York State Rifle and Pistol Association v. Bruen standard, where the government must prove affirmatively that firearms regulations are part of the historical tradition that delimits the outer bounds and the right to keep and bear arms. Now, what we're looking at is this conduct covered by the Second Amendment? Can the government prove up that this is something that was regulated at the time of the adoption of the Second Amendment? And they fall short.
Exactly. And, bear in mind, and I know the anti-gun argument, and it sounds very common sense, which is we don't want wife beaters to possess firearms because there's lots and lots of evidence about wife beaters' propensity to then be wife murderers. I get it. However, these are not convicted wife beaters.
No.
Right?
No, this is sometimes just a civil proceeding.
Exactly. This is, you need to be ready to respond to the anti-gun argument against this, which is that we do not take people's constitutional rights away from them in this country based on mere allegation. Our standards are higher than that. Nasty allegations though they may be, It's just not how it's done here.
No, and I think what's important to point out also is that we have I think there's a good discussion here. They pull a quote from now Justice Amy Coney Barrett talking about, when the government looks at regulating rights, do we look at the individual? Do we look at these groups of people? And this, I think they also address, and I thought this was very interesting, we kind of talk about this circular argument that we find in the Heller case and we find in the New York State Rifle and Pistol Association case of, they talk about law-abiding gun owners, peaceable gun owners. Well, can the government just pass a gun law and therefore you become no longer law-abiding, therefore making you not have Second Amendment rights? That doesn't make any sense. There's no limitation there.
Exactly right. So here is how egregious 922G8 actually is. And again, good fodder if you are having this debate with someone who is a little bit anti-gun, which is, it is so easy to be placed under one of these orders. If you're getting a divorce in the state of Texas, and I'd imagine the same thing's true in many states.
Good examples.
You are placed under what's called a standard order, which basically just says, everybody who's a party to this divorce needs to behave themselves, right? Don't drain your bank accounts. Don't flee the jurisdiction.
Yeah. Keep the status quo.
Keep the status quo. Don't destroy your property. But one of the things in that order that is standard language, goes out to everyone, regardless of if there's been any allegation of family violence, says, don't hurt each other. Don't harass, stalk, threaten each other, and don't do any physical violence to one another. And so every single contested divorce in the state of Texas in which a standard order is issued, which is most of them.
Yeah, that affects a big chunk of people.
Huge chunk of people. All those people have lost their gun rights under 18 U.S.C. 922G8 for the pendency of the divorce. That's how easy it is to get your gun rights taken away under this statute. That is why it must fall. The Fifth Circuit has done the right thing. Again, thank you, Fifth Circuit, and thank you, great state of Texas.
Yeah, so the court concluded in this case, obviously the statute was unconstitutional. They overturned his conviction, and they said they had to vacate the statute. So we see the Fifth Circuit getting this right here with that particular provision of law. What do you see happening with other circuits? Because I think they faithfully interpreted the New York State Rifle case.
The Fifth Circuit is one of the only circuits faithfully interpreting New York State Rifle and Pistol versus Bruen right now. So just be aware, this is not nationwide law yet. What will happen? Other circuits will interpret it. They will probably interpret it differently. And then if they do so, this will go up to the Supreme Court, and then we will have new law of the land. But again, this is a very, very slow process. And I know the lawyers get excited every time little things, sort of happen. But this is a big little thing. It is a huge step in this fight. And it is, it's coming.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. And until next time, we're the Armed Infringement.